Seeing that we are dealing with these PFMA charges, perhaps let me take you to a different but related issue. Ms. Sillo, please.
Yes, Chair.
Let me do so, Advocate Johnson. I'm sure you know what sections 155 and 156 of the Criminal Procedure Act provide with regard to joining accused persons in the same set of criminal proceedings. Perhaps for the record and those viewing these, for their benefit, those viewing these proceedings, let me read both sections. 155.
Chair,
yes.
Apologies, we are trying to project, so perhaps when you read, it will be projected as well. Thank you.
All right. Section
157.
155 and 156.
155
and 156, so Criminal Procedure Act.
It's coming up. Thank you.
155 is headed, persons implicated in same offense may be tried together. So I would say, please underline even that heading itself. Of course, our law and interpretation says a heading may be a guide, but is by no means determinative. But I will say, let's underline it. Then the subsection 1 reads, any number of participants, and I emphasize what follows, in the same offense, so you underline same offense, may be tried together, and any number of accessories after, again underline, the same fact may be tried together, or any number of participants, again underline, in the same offense, and any number of accessories after that fact may be tried together, and each such participant and each such accessory may be charged at such trial with the relevant substantive offense alleged against, I will say, them. Surely, in charging General Masemula together with people charged with fraud and corruption, you did not rely on section 155, subsection 1. I must be correct in that view.
That must be correct.
That's correct. Okay, let's go to, I don't think subsection 2 is relevant, so let's skip to section 156, which is headed, persons committing separate offenses at same time and place may be tried together. That too is quite crucial because I'm interested in if we look at what Commissioner Masemula is charged with, one immediately wonders if it can be said that he committed offenses at the same time and place with the people that he has been lumped with. But again, I will make the point I made earlier that a heading is merely of assistance and not necessarily determinative of the interpretation to be given to a statutory provision. Okay, let's go to the provision itself. Any number of persons charged in respect of separate offenses committed at the same place and at the same time. Underline that. Now it's in the substantive part of the provision, so no longer just the heading. And, or at about the same time. So that too, at about the same time, may be charged and tried together in respect of such offenses. And then here's another crucial part. If the prosecutor informs the court that evidence admissible at the trial of one such person will, in his opinion, also be admissible as evidence at the trial of any other such person or such persons. Do you think this subsection applies? Or rather, this section, it has no subsection. Section 156, do you think it applies? In what way has General Masemola, based on the PFMA charges, committed those PFMA charges at the same place and at the same time as the commission of the fraud and corruption? Surely that cannot be suggested, I do not think. Same place, same time, about the same place, same time as the commission of the fraud and corruption? Not by any stretch of imagination, I do not think.
Correct, Chair.
So General Masemola was wrongly lumped with these other people. You must accept. You accept that?
I see that.
You certainly must. Now, even when you look at jurisprudential precedent, I will refer you to, I know you're a good prosecutor. I watched you arguing, which appeal was it? The Pistorius appeal. You are actually a good advocate, I think, on my assessment. I will refer you to jurisprudential precedent with regard to the court's exercise of discretion under section 1, under one of the sections I've just referred to. It should, I think, be relevant more to 156. Let me just see if the case was dealing with 156. Anyway, let me not waste time. Let me just read you what Trolip J.A. held. He says, in exercising its discretion, the trial court has to weigh up the likelihood of prejudice to the applicant accused. That is, the applicant accused would be the one saying, please, please, let my case be separated from the cases of these other accused. So the applicant accused, resulting from a joint trial against the likelihood of prejudice to the other accused or the state if their trials are separated, and decide whether or not, in the interest of justice, a separation of trials should be granted. Prejudice there means prejudice in the sense that no injustice should be caused to the party concerned, including the state. If we look at this, but what's crucial is that you've already accepted that in any event, General Masemola ought not to have been lumped together with these accused persons that are charged with fraud and corruption. Bear in mind that yesterday you accepted already that General Masemola is not complicit in fraud and corruption. Now you accepted now in my engagement with you now that he ought not to have been lumped together with these people. Now that he has been, surely, and based on this principle, you must also accept that he would suffer the sort of prejudice that Trolip J.A. says an accused person should not be subjected to. And I cannot see any countervailing arguments to the effect that the state will suffer any prejudice if he is not lumped with these other accused persons. Do you agree with me?
And if, I think when it was flighted, section 157.
Can you just respond to what I suggested to you now?
And I wanted to say that because of, if you read 157,
yes.
that becomes a bit more, is more appropriate then in the circumstances and given the jurisprudence.
Yes, yes. But you basically agree with me, you've already agreed that he ought not to have been lumped together. Then I'm making another point, although related, which is that he will definitely be prejudiced in a trial that lumps him together with these other accused who are charged with fraud and corruption, both of which he is not charged with. Do you accept that?
I accept that.
Now, a question that goes to what I've always emphasized, I think I did so even on the first day, which is that we are not trying to suggest that the General Masemola has committed no offenses, no. But, and this is something that Commissioner Baloyi's question touched on, we want to know why this was done. Why was this done? You've agreed very easily, you know these principles, you apply these sections all the time. Why was this done? Why was Commissioner Masemola lumped with these people, charged with fraud and corruption when he is not? When he is charged with the statutory offenses provided for in the PFMA, why was he lumped with these people? At face value, it seems to me that this must have been done to embarrass him, to taint him, and to make the public, or to cause the public to see him as also being complicit in fraud and corruption. People are not going to, ordinary members of the public are not going to analyze this. He stands there with people charged with corruption, fraud. He stands there with them. And most of the noise when the case is talked about is going to be about the fraud and corruption. People are not going to delineate and say, but not Masemola. Do you see what I mean? So this was done, I suggest to you, to embarrass him, to taint him, and to make him look as if he too has committed fraud and corruption. That was calculated, I suggest to you. What do you say?
Chair, I understand. I gave the contention that I did, that the prosecutors put him in one matter because there's the serious complex fraud corruption, and it would be one matter when they lead the evidence with the PFMA. I'm giving you the explanation that I have for the prosecution. I accept that this matter, he should be separated, but at no stage, Chair, was there an intention to embarrass. I can understand the optics thereof, but at no stage in the charging of Commissioner Masemola was there an intention that he be embarrassed.
Were you involved with the decision to join him as a co-accused in this, with the other accused? Were you involved with that decision?
Yes, the prosecutors take the decision. When we were briefed, we agreed that he's charged only for the PFMA.
No, my question is, someone made the decision that he will be accused number, whatever number, on that gallery, right?
The prosecutors.
My question is, before that decision, or when that decision was made, were you party to that decision when it was made?
That he would be added at the end.
That he's added as a co-accused with the other, however number, whatever number they are.
Based on the contentions that I've given, which was given at the time, yes, ma'am.
You see, what's problematic with this is the fact that you have already agreed that in terms of the sections, he ought not to have been joined at all. He ought not to have been. Now, what makes this situation worse is the fact that he is being joined down the line. Not that it would have been correct if he had been